And that's you ready to go.
Okay, thank you very much. Good afternoon, everybody. That's our meeting officially underway. Before I proceed, can I just ask that everybody does turn their video on just for a moment, just for initial checking. Just so, because if everybody turns it on, then everybody can hear me. I just want to check that everybody's hearing me clearly. And in the course of the event, just a thumbs up, perfect, yeah, just a thumbs up if you're needing to agree with anything, or a wave if you're trying to attract my attention, and the rest of the time you can turn your video off or mute your microphone as you require. So I'll keep going on the assumption that everybody's hearing me reasonably clearly. My name's Elspeth Cook. I'm a reporter with the Planning and Environmental Appeals Directorate. I've been appointed to hold the inquiry and report to Scottish Ministers on the application. It was submitted under Section 36 of the 1989 Electricity Act by Vattenfall Wind Power Limited and is for a proposed wind farm at Clashindarroch Forest to the south of Huntly in Aberdeenshire. It's generally referred to as Clashindarroch 2. In Section 36 cases, it is the ministers that will decide whether or not to approve the application after consideration of my report of the inquiry. So this meeting concerns the arrangements for the inquiry itself and the associated procedures. It doesn't form part of the inquiry, and no evidence on the merits of the proposals would be heard today. I circulated the agenda in August, and therefore you've had an opportunity to consider my current thinking on this matter. Consequently, I'm hoping we can progress through the agenda quickly and really only spend time on any points where there's a disagreement. A bit of housekeeping. You'll know that the meeting is being recorded and broadcast live online, and Graham will be staying with us in case of any technical difficulties. In due course, the recording will be stored and available to view back on the website. In accepting the invitation to the meeting, you have already agreed to being recorded. Even though it's a virtual meeting, if your microphones are on for any reason, it's still quite important to turn off your mobile phones or make sure they're on silent. You also might find it useful to use the grid view offered by this meeting platform, and it just allows you to see if other people are looking to come into any of the discussions. I also expect everyone to adhere to any current COVID restrictions and guidance applicable at your location, especially if you're attending from a place of work or sharing your office with any other participants. If for any reason I think the appropriate procedures are not being followed, I reserve the right to close the meeting and make alternative arrangements to reconvene. I haven't planned any formal break in today's meeting. I will need to see how the timing goes, but we'll have a look after an hour, see how far we've got on through the agenda, and we can decide then if we need to take a break. It's always more tiring than you expect when you're conducting a meeting online. And I'll pass on to the introduction stage now. I'll probably invite the main parties to introduce themselves and the members of their team, and I'll start with the applicant, please.
Thank you, ma'am. Yes, I hope you can all hear me. I'm on my own iPad, so not guaranteed. My name is Marcus Trinnick. I'm a solicitor of Queen's Counsel, and I'm instructed in this case by Kirsty Smith of Eversheds, who's in this meeting I see, and I'm also accompanied by Nicola McLennan, legal counsel at Vattenfall, Alison Doherty, who's the project director, and I see that Alison Sidgwick, our planner of Stevenson Hallidays, also in the meeting.
Thank you. And Aberdeenshire Council.
Thank you, madam. And again, I hope you can hear me clearly. My name is Martin Ingram. I'm a principal solicitor with Aberdeenshire Council. Our instructed counsel, James Finlay, was unfortunately unable to attend today's meeting. Therefore, it will be myself who will be leading the council's position today. But also in attendance, we have Arlene Gibbs, who is principal solicitor within the legal service, and also Stuart Mudison, who is senior planner within the planning service. Thank you.
And the other parties that are with us today, maybe starting with the two that are represented. I see Mr. Kelly there. We'll perhaps start with him.
Thank you, Ma'am. Ian Kelly of Ian Kelly Planning Consultancy Limited, representing the Carback Trust, the Carback Community Association and Belcherry Farmers Partnership. It will only be myself in the call today. Thank you.
Thank you. And Susan Shaw.
Good afternoon, Ma'am. My name is Susan Shaw. I'm a solicitor and partner of the law firm Living Law. I'm an expert member of the United Nations Harmony with Nature Initiative, and I'm instructed in appearing this matter on behalf of Wildcat Haven. For the purposes of the note of today's meeting and who's on the call, I'm accompanied today by my client's principal, Dr. Paul O'Donoghue. I think he's had some technical problems joining, but should be with us in a few minutes. As well as our lead ecologist from our project team, who's Mr. Dominic Woodfield, of a director of Bioscan UK Limited.
Thank you. And the other parties that are coming into the call today. I'm trying to see, I'm expecting Julian Newman.
Me?
Thank you.
Okay.
And Colin Mackenzie.
Hello, I wasn't intending to speak today, but just interested in proceedings. Thank you.
Yep. No, that's fine. It's just helpful for me to make sure I understand that everybody's here that needs to be here and what their role is. Thank you. I was advised in the run-up to the inquiry that one of the other third-party objectors, Richard Hammock, wishes to participate in proceedings, but he can't attend the PEM today. I was hoping to get an indication from him in what way he's looking at participating in terms of the inquiry or hearing sessions, but if I get details of that, obviously they will be shared with you as soon as we know. Are there any preliminary questions or issues that we need to deal with just before we get underway with the rest of the agenda? No, that's fine, thank you. So item 2 is the identifying the code of practice and how the inquiry would be handled. For those of you who deal with these cases all the time, this is not new information, but it's useful to rehearse it for the benefit of those watching the broadcast and for those who are new to the process. There are no detailed procedural rules for conducting inquiries under the Electricity Act. However, the DPA operates a code of practice which is modelled on the 2013 Planning Appeals Regulations, and I expect to apply the code of practice in this case. The document's available on the DPA website, and I'll put a link to it in the note of the meeting. The code is designed to ensure the process is fair, robust and efficient. It recommends that I put in place arrangements that ensure all parties are clear about what's expected of them and that what will happen before, during and after the inquiry or hearing session. It also allows me to tailor the inquiry procedures to each particular case, which means only significant matters in dispute need be considered by matter of formal inquiry session. Therefore, in addition to the inquiry route, where those giving evidence are open to cross-examination, the code offers 3 other options that are less formal. Hearing sessions, where the reporter chairs a discussion of the issues, further written submissions, where the parties are invited to expand upon or clarify their evidence on a particular issue, or to opt for no further procedure, where it's considered sufficient written material already exists on a particular issue. You'll see in the agenda and its annexes that I have already set out where I think this flexibility could be applied, and we'll discuss these arrangements in more detail in due course. I also want to draw to your attention a recent publication called Guidance Note 23, Managing an Efficient Inquiry Process. I don't intend to repeat all its provisions, but it is quite new and not all the inquiries have followed this process. And this is one of the first ones that will probably follow the new process from beginning to end. There are a few points that I want to highlight to you because they obviously make a difference to how I've viewed some of the matters procedurally today. The first is that there is now an expectation that I will complete my report by week 50, starting with the point where the application was made available on the EPA website. And that there is an expectation as well that I would secure inquiry or hearing sessions around week 30, which is why you will see that my timetable reflects that position. And there's also a move to ensure that we prepare a single document list and that these documents are submitted as early as possible in the process. And as a last point, that the parties provide a way of summarising their own case that I can use in my report, so that I'm not summarising other people's cases for them, and that would greatly help me in concluding my report work. As another matter, slightly separate, is the issue of site visits. At the present time, I intend to carry out unaccompanied site inspections. I don't envisage any need to repeat this on an accompanied basis at the moment, but it is possible through the course of the evidence that comes forward that I might have to review this. So I would obviously make arrangements to advise you if I felt the need for further site visits was necessary. Does anyone have any general queries on the code of practice or the guidance notes, or indeed my site visit arrangements? Oh, Mr. Trinick.
Just one question, ma'am, and that relates to the summaries of cases. It's a topic I've raised before and at other inquiries, because that's quite a new thing, as we all know. And while I can see it's useful to have a summary of one side of the story, that is your case. In closing submissions, I would normally provide a summary of both sides of the story, which includes our side as well. Can I get some clarity as to what it is and in what format you're expecting it, so far as the summary is concerned?
Yes, the original plan was to try and use the precognitions, which tend to be a shortened and focused summary of the witness's position and therefore the applicant's position on a particular matter. And that was the original intention, and certainly that's set out in the guidance note. But I appreciate, and I think the guidance note refers to it, is that closing submissions can bring forward certain aspects of the argument that it can develop, it can change as a result of the inquiry and hearing sessions and the examination of that evidence. So there is an acknowledgement that the summary would then be dependent and influenced by the closing submissions that come forward. So I don't have a strong view on setting out for you exactly how I want you to lay it out in some kind of structured way. I'm just looking for parties, when presenting any evidence, that they consider that there is a duty on them, as far as possible, to try and summarise the case in its entirety on that issue, so that it can be brought forward in their words and with their emphasis. I wouldn't personally have any issues if that summary starts life perhaps in the inquiry statement, should it be linked to the actual inquiry session. But it also, and I'm going to come with it as well, there's benefits in it in terms of the written submissions elements of the inquiry as well, that time is taken in those documents to create an executive summary, headlines that allow me to draw through quickly the main areas of the case or the concerns of the various parties. Does that help at all? Because I think we're still in the early stages, so it is evolving.
Indeed, ma'am, that's very helpful. If we chose to do what you need, and I understand the need for it in precognitions, would you be prepared to waive the 2,000 word rule to enable us to make the precognition more than just a signpost to where the evidence is found?
Yes, I think in my agenda I do say that we can work with a longer precognition especially as obviously we're going to come to that we're looking at taking recognitions as read, and that perhaps a shorter, more focused summary could be provided for working purposes in the inquiry session. And so the provision is there. I think we're looking to try these ideas. I think perhaps you're aware of it, and Mrs. Smith are aware of what we're trying to develop here. So I'm still quite flexible just now on how it appears, and certainly I'm not going to be enforcing strict word counts if it means that we do get a more useful summary from the evidence that you present.
That's very kind, thank you.
Were there any more queries on that, Mrs. Shaw? Ms. Shaw?
Thank you very much. Just a general point in relation to site inspections. I think my client has a concern that it may be too early to take a view about accompanied and unaccompanied inspections, and they would obviously seek to limit the need for any accompanied inspection. But given the nature of this site, which is quite vast, I think that we feel that there may be elements of that would benefit from accompanied site visit.
And obviously, in Fort Respect, obviously there's a great deal of ground to cover in terms of viewpoints, and I would be reluctant to do an accompanied site inspection of all the viewpoints, because it can take a number of days to get around everything. But I accept there might be benefits in accompanied elements to my site visit, and I certainly would appreciate your thoughts on that at some point through the evidence, if there's particular areas or locations that you want me to see as a general comment. And then if there's areas where you feel that the accompanied approach would be beneficial, and that would go for any of the parties to the inquiry. But I would obviously look to focus that as far as possible, just bearing in mind two things. Obviously, there is the issue of our current COVID restrictions and issues of travel and sharing cars and all these concerns that we didn't have a year and a half ago, but also in terms of time, and just to make sure we're using the time productively and in a focused way.
That's very helpful. I would agree with that.
So I think that takes me to item 3 on the agenda, and that's about planning for the inquiry and the hearing itself. I think under this section I would be looking at overall dates without any kind of commitment to particular processes at the moment, but this might be an opportune time to do that. So you'll see on the agenda, DPA is currently moving back to in-person inquiry and hearing sessions. We're still kind of in transition as such. There are still committed inquiry events that are still proceeding virtually. But I obviously am aware of a level of uncertainty still around the issue of the COVID regulations and safety measures, and that these could still change in the coming months. And so there's a level of uncertainty essentially in what an in-person inquiry might look like in 3 or 4 months' time. So I'm going to be monitoring that in the coming months, and we need to kind of be aware of it. I'm sure you will be yourselves. I'm going to retain, and I put that in the agenda at all times, the option to revert to a virtual event to respond to any of those changes if I feel that we can't safely carry out an in-person inquiry. I wouldn't do that obviously without consulting and engaging with you, and you'll see that I've made a commitment to do that. So, and you are going to be aware of why I'm doing it. I'm not going to do it on a whim. You're going to know that there's been a change in procedures or guidance that made me reconsider how we take it forward. I've also looked at in the timetable the possibility of a second pre-examination meeting. Now, I've no firm ideas of a date other than it needs to be between the end of us securing any kind of written submissions process and the start of the lead into the inquiry. But it's just an opportunity perhaps to time it in a way where we can look at things like the ongoing COVID situation and how we change things. But with that in mind, and bearing in mind the level of uncertainty still around COVID, I really want to canvass all the parties now as to whether or not they would feel better if we did move forward with a virtual inquiry or hearing session, generally because it's less likely to be affected by any changes and also by anybody's personal circumstances, such as a need to isolate or illness that might maybe make travelling to an in-person inquiry difficult. So I'd probably just see if anybody has any views, particularly for or against the virtual inquiry option when we fix our dates. Is there anybody got a view, Ms. Shaw?
Thank you very much. Just to add on this point that we are obviously supportive of the resumption of in-person events and where it's safe to do so. Naturally, an in-person event would be our preference, and we feel that that's necessary for effective public participation from the perspective of the Aarhus Convention, particularly dealing with a rural community such as Aberdeenshire. We're content that in-person proceedings could be restricted to the inquiry sessions. I think our general experience is that inquiry sessions are better handled in person. So if there are other elements, we would of course be supportive of those to be held virtually.
Ma'am,
Yes, thank you.
we're fully supportive of the approach set out in the agenda, which seems very sensible. We are very strongly of the view that there should be a preference for in-person inquiries, and I think Susan Shaw and I agree there. However, to give access to those who feel uncomfortable in attending an in-person session, we can do what was done in September, gosh, was it last year or the year before, for the Clashindarroch and Rothes inquiry, where there was an in-person inquiry, but some people to give evidence by video, and it worked perfectly well. So it can be done. So we're fully supportive of what you say. We have been talking to the council about venues. No doubt we'll pick up on that topic. We don't need to deal with it in detail today.
Mr. Kelly?
I would just like to agree on behalf of my clients with what's said. The preference is for in-person inquiry, and I'm sure we can find a venue. But at the same time, we recognise there are risks, and therefore we are basically perfectly happy with what's set out under agenda item 3 in the agenda.
I think Mr. Trinick's point about this idea of oh, sorry, yes, from the council, Mr. Ingram.
Not at all, ma'am. Just again to confirm, essentially the council's position is the same as the others that have been represented to you already. That our preference would be an in-person meeting, subject of course to any COVID risk management procedures that might require to be in place in order to be able to facilitate that. As you've already been informed, we have been liaising with the applicant to identify suitable venues specifically within the Huntly area for the inquiry, and further to that, just to offer that we would be happy to lodge a list of prospective venues for your consideration if that would be appropriate.
Yes, that would obviously, we would come to that through our case officer that's working with me on that. We'll be starting to look at venues once we'd worked out a couple of extra things. I'm going to come to that in a minute. I appreciate Mr. Trinick's suggestion, this idea of working with the potential for some kind of hybrid where there is an element or a provision for certain people to choose to come in remotely into an in-person event. I certainly have a look at that. It's technologically different from one or the other, and I know that the department is looking at it as a sort of what they call blended, as a blended procedure. And I think so we will be looking at where we could develop that, if that's of assistance to any of the parties that want to participate. I think it's what's important, I think, and I need to be conscious of, and it will come back to this question of venue, is we need to make sure that it's large enough for everybody that has to participate. And then we work out whether or not the public can attend over and above that, and whether the rules are such that the public are able to attend based on the risk rules that apply to public events at that moment in time. So for me, there is an issue of the in-person option potentially, depending on the venue, creating difficulties for members of the public as opposed to participants from attending. So I need to be conscious of that, and we need to make sure, that's why we need to make sure that the web broadcasts are all set up at the same time. But I think it's something we need to work on, and I think it might be that this second pre-examination meeting might be beneficial because it will allow us to kind of be more specific once we're further into the process. Just on that point, it's likely as a part of my note of the meeting, I would be looking fairly soon for the parties to confirm how many people they would need to have in the room with them, so that we can start looking at these venues and the suggested options that the council and the applicant have been looking at, because that's so important. It's often about the other people that are there as well, because they need space standards and separation distances. It's not just about the witness and the lawyer. So we need to sort of take that in mind. So that will be part of the note of the meeting, is really start getting ideas from you regarding the size of the whole team on the day at any particular inquiry or hearing session. And that takes us to the first area where I know there's a little bit of concern, and I'm obviously aware of it. I'm not insensitive to it, and that's the issue of the inquiry dates. And the reason for highlighting the issue of week 30 in my summary is obviously we are now operating a system where ideally is we get to the inquiry and hearing session at week 30, and the 17th of January week that is in the provisional timetable was reflecting that, and that had to be my starting point for my discussions with you. I realised that for lots of reasons, which are quite specific and unique and may not be repeated with any immediate future, there may be difficulty in all the participants being able to do those that week. So if I could get from the applicant and the council any particular difficulties they have with that, so I can properly document that, and we can really understand why another week other than week 30 is going to be preferred in this case. Mr. Trinick, perhaps.
Okay, thank you. I have an inquiry in Highland on the week of the 10th of January. I simply could not go from one inquiry to the other just like that. It would be unfair to both clients. I wouldn't do a decent job. After that date, I'm to blame for taking a COVID delayed holiday, which I'm really anxious not to give up. So that takes us, taking account of other witnesses or other witnesses' availability, to the date we suggest, which is the 28th of February. And I know that's after week 30, and I do apologise. I know what Guidance Note 23 is aiming to achieve. We've been kicking reporters for years to get their reports in time, so now it's coming back to bite me. But their request is for the 28th of February.
Right. What about the council's position on that?
Thank you, ma'am. I'll start by saying that in general terms, the council's own preference would be that any hearing could be held sooner rather than later. Now, in terms of an earlier date, we are actually in the same position as what's just been related to you by the applicant's council, that if it was a date in January or February, it would actually be a potential issue with the appointment of our current council, James Findlay, although he has asked that we revert to him in the first instance if there is a date set for January of next year. However, from the council's internal perspective, the more pressing concerns from our perspective is an issue with regards to staffing, resource and capacity issues later into the spring. Without going into too much detail, one of the aspects in particular is that the same key planning officers who may be involved in this case will also be involved at that time with, you may or may not be aware of there being a carbon capture scheme project which will be taking place, and a larger amount of work will require to be undertaken for that particular project, unfortunately around about the same time as March to April time. In general terms, however, if the inquiry is set for a later date, we would be ultimately happy to go with whatever date you ultimately choose to go with. But if it were to be set at a later date, we would be potentially looking to work on an informal timetable with the applicant so that we can look to potentially have some of the documentation agreed in early course where possible, so as to relieve some of the potential clashes that our own internal planning officers may have later on in the spring. Thank you.
Okay. Well, and specifically then, obviously, Mr. Trinick's earliest date he's suggesting is the 28th February, obviously that week beginning the 28th. Is that a week that would be fitting in with your planning officers and your staffing commitments?
Thank you, Matt. Yes, I think ultimately it would require I think that may require the appointment of new council for ourselves, but I think in that respect, I suppose a date at that time may ultimately be better than pushing it forward into March or beyond. And as I say, we'll ultimately be willing to work with whatever date you ultimately decide to go with.
Okay. Do any of the other parties, obviously I'm not meaning to exclude Mr. Kelly, obviously have a view into these dates?
January would be difficult for myself and for my clients, the community clients, because of ongoing community consultation processes which they have underway. I've already informally discussed the other dates with them and looked at my own diary, and I would very much support the week beginning 28th of February for the holding of the inquiry.
Does anybody else have any particular issues around dates that they want to share before we kind of move forward? I'm not seeing any hands coming up. One of the real benefits is to get to the point where we can at least fix the week that we're aiming for, and to try and do that today if at all possible. Not meaning to put undue pressure on the council or their legal counsel. But if the 28th is working, the earlier is better for me. The earlier the date is better for the council in terms of its other staffing pressures. If you're looking at my overall timetable, which if I was going to look at it later on, it's at the annex at the end of my agenda. You'll see we're working on a sort of so many weeks after the note of the meeting is how it would work, and then so many weeks before the inquiry. So, and then there's a sort of area of limbo as such in the middle where work can progress or not, depending on the commitments of the participants. If we were moving to the end of February, it would mean that all the main documents for any inquiry or hearing session would not have to be submitted until into 2022, and not in the first week either, which would mean that they shouldn't be overly affected by any holidays that people take over the Christmas and New Year period. So certainly a February date makes for a slightly easier submission arrangements in terms of your own staff commitments. We don't know what they are, but I'm sure everybody will have their own various commitments over Christmas and New Year that might make preparing for a 5th or 6th of January delivery date quite difficult. So certainly I'm a little bit worried Mr. Ingram deciding his own timetable for submitting information, but I have no problem with anybody doing anything earlier than the dates that we eventually agree for the inquiry. And that's entirely up to yourselves. It is about the latest date is always about these lead-in periods. Mr. Trinick.
Yes, well, I've heard what Mr. Ingram said, and thank him for that. It was very constructive. As far as I can see, on the 17th of January, which is the equivalent date for submission of inquiry reports to the earlier one you set out on the agenda, 17th of January really equals 17 December, because between 17 December and 17 January, there's so many people off or doing other things that we may as well complete the processes that month earlier, if that helps the council. And even if other parties don't want to do it, we can agree with the council to make sure they get everything from us they need by that date before Christmas. That's not a problem for us.
Well, we might return to that on the individual items. Oh, Mr. Ingram.
Thank you, ma'am. It was just to clarify, it wasn't my intention if it was picked up that way for us to be setting the timetable in respect of the hearing timetable going forward. But as I say, and I appreciate the applicant's position in relation to that, to be willing to work with us in that regard. I think it was more in terms of just an informal arrangement where possible with the applicant, just to be able to work on some of those details in earlier course. But thank you for that.
No, that's fine. Well, we can have a look at using the December date. It gives a very big lead-in time to the inquiry session, and that there's no harm in that. It's very helpful. It certainly reflects the fact that over Christmas and New Year you do lose 2 to 3 weeks of working time. Not everybody, but there's always somebody missing at some point in that process. Can we head on into the next items on the assumption that any in-person or virtual inquiry or hearing dates are now sometime in the week beginning the 28th? If we do that, and we'll move on into the next part of the agenda. So item 4 is dealing with information that I think that I would like to have in the in really as soon as possible, really, in terms of moving things forward, and this is just reflecting what's in the agenda. There are 3 things that I think need to be updated. The applicant recognises themselves in their position statement the need to update the cumulative landscape and visual impact assessment to take account of any changes in consented or proposed wind farms since 2019, when the initial documents were concluded. And the point that I am interested in, well, not the only point I'm interested in, but the point I want to raise is the change in any visual impact associated with the turbine lighting, the aviation lighting. The applicant confirms that they're working with a reduced scheme, and I would like to see a bit more information on that, because a lot of the parties make reference to nighttime effects, and I would like to see a more up-to-date assessment and visualisation profile for the lighting scheme. The third item, which is quite common as well, is to update any changes in policy and guidance that's taken place since the last set of planning documents were produced for this case. You'll see that I'm looking at 3 weeks from the note of the meeting to get the updated landscape visual work, and then the policy work to follow on and to be caught up in any hearing statements, assuming that we have hearings on policy matters. It looks like that we will do. So that's really how I'm looking to approach that. I always say it's really mostly a matter for the applicant, really, initially. Is the applicant able to work with these timescales, so 3 to 4 weeks timescale into October? How are they fixed for delivering the updated visual information?
Thank you, ma'am. The work is underway as we speak. I think 4 weeks may be a little tough. I'd asked for 5, if you wouldn't mind that. But certainly 5 weeks from the date of a note of the meeting, assuming that note comes out next week, that's fine for us. In terms of the policy material, I've noted your suggestion. That seems very sensible as well. There's an awful lot going to be happening with national policy, as we know, between now and the inquiry, if it's held in February, in terms of MPF4. So there will be a lot of updates.
I'm wondering if the December deadline, is that going to be potentially tight? I suppose we're second guessing when MPF4 might be actually published. Perhaps we could, if we're looking at a second pre-examination meeting, it might be that we have a slightly different date for any information coming forward on policy, and we can look at how the MPF work has evolved in the autumn, and maybe just reassess that. Okay, thank you. It would be useful if I could just say as well here, in presenting any of the additional landscape and visual information, I would need one hard copy of certainly of all the visualizations in the same format as the existing information that I currently have. I'm not sure if any other parties would need that for the inquiry purposes, but perhaps we can exchange emails on this afterwards if anybody else needs to gain access to a hard copy. And that takes us on to, oh, there was just one other point. Oh, sorry, Ms. Shaw, sorry.
Thank you very much, ma'am. I just wondered if I might come in here. I had written to the reporter to indicate that we understand there's an outstanding issue of access to information between our clients and the developer. I think this relates principally to some of the confidential annexes. Our submission is that it's quite important for their proper participation in the proceedings that our client would have access to some of that information. So I just really wanted to raise it today. I hope that we'll be able to take it offline with the developer perhaps subsequent to this meeting. But I understand that there is precedent from other inquiries in which our experts have been involved to have access to that, subject to suitable documentation being in place.
Thank you. I wasn't sure, obviously from your email, I wasn't sure exactly what it was you hadn't had, because it didn't mention the confidential annexes. Mr. Trinick, do you have a view on how we could share some of that information?
I'd prefer to take that offline with Susan Shaw after the meeting, but now I know your expert is Dominic Woodfield, who I know very well. I think we'll have less concerns than we might have had, and I'm sure we can sort something out. But I'd rather do it after this meeting, if that's okay.
Yes, certainly, that's fine. Thank you. And the point I was just going to raise, the supplementary information I've mentioned, section 19 of the Electricity Works EIA regs, it would obviously be 19 and 20, thereby it would be a direction for information for an inquiry. Just want to confirm that. Thank you.
Thank you.
That takes us to other additional information, which is, I'm
sorry, ma'am. My apologies for interjecting. Just before we move off of that particular topic, it was just to say that with regards to the requirement for a first draft set of conditions, I was wondering whether it can maybe follow on the lead of the applicant. It would probably be advantageous from our planning services perspective to have a little bit more time in order to be able to prepare those as well. So I was wondering whether it could maybe fall in line with the previous suggestion from the applicant, and if this could potentially be made 5 weeks from today rather than 3 weeks.
Okay, well, we're just about to start that item, Mr. Ingram, so it's fine. Well, I'll pick that up as we go through. So the next information is really information about preparing for the inquiry and to help with the eventual summary of information that we provide for ministers. First of that is the set of draft conditions that you've picked up on. The second is a core document list, and the third is a statement of agreed matters. I had looked to see if all of those could be aligned in that first period, this 3 to 4 weeks after the note of the meeting, just to get everything underway and to make sure that the provisional work is done. With both the conditions and the core document list, I would be looking at in making arrangements for those to be fully updated and as things progress, because obviously as cases are written and written submissions are exchanged on things, it could be that conditions alter, and obviously core documents will change as people's evidence starts to become more fixed. So really I'm happy to look at a slightly more generous time period for that. If that's of assistance, it'd be quite useful to try and keep these things aligned as far as possible, because it allows the case to move forward with different sets of information arriving in a group in terms of process and exchange of information with other parties. My first question obviously is was the timescale for the draft conditions, but I also wanted to make sure that because the discussion on draft conditions at any hearing, if we do have one, is dependent on the level of disagreement or conflict, if there is, in the wording of the conditions. It would be useful that whatever date we pick, that we have these draft conditions with any potential difficulties identified before we have another pre-examination meeting. And at that point, we can then determine the scope of any further discussions and that need to take place on those on those conditions. So that would be that's my backstop, is actually to make sure those conditions are ready so they can inform our final arrangements for any hearing or inquiry session. Would parties be roughly agreeable with that as a point, a general principle? We can pick a date in due course. The second point really is on core documents. Again, this is something that's evolved. It's been evolving over a year or two now, and I think it certainly came into its own with the virtual inquiry process. And that's this idea of a single core document list, where everybody shares one core document list. It's generally managed by the applicant, and all the parties, including those that are on the opposite side of the argument, present and share their documents and use a referencing system that's common throughout. We know it works well, it's easier at inquiry, and it's easier to manage. But we're advocating that as part of our new procedures. It generally requires the applicant to agree to take charge of that. So I suppose the first question is for Mr. Trinick, would the applicant be willing to be the holder of the core document list and to manage it going forward?
Yes, of course. And I'm just going back 1 point to conditions. Just something.
Oh, sorry. Yeah.
Final point again. The draft conditions are just about there and ready to be sent to the council now. So that they'll be on their way within the next week or two. In fact, next week. The core document list. I think Kirsty Smith has been indeed working with the DPEA on the new core document library, involving unique reference hyperlinks or URLs, whatever they're called, for each document on the list. So that what we will put together, yes, we'll take responsibility, is a draft which uses in part the available DPEA core document library, and then adds to it other documents. But each of those added documents will have a hyperlink. And then people will add to the list as they see fit.
Right, I was just going to obviously come to the issue of the changing procedures. It was really just to let the other parties know where we are with that. They might not have come across this before. As you said, Kirsty Smith has been helping us provide some input to the processes. This case, because this is one of the first cases that's going to follow the guidance note from beginning to end, it's also going to be one of the first cases, there's one or two, are going to be looking at this new core document approach. Really the purpose of it is about it's being more streamlined and efficient. And for those of you who aren't normally involved in this, essentially we hold a lot of the documents that the parties then rely on. We already have them, and we've stored them and saved them onto our digital case file. If we can use a hyperlink approach, it means we don't have to process that document a second time, and you don't have to submit it a second time. You could just submit the hyperlink to a document that we already have. So essentially, there's two sources of these. There are the case file itself, which has already got a lot of information in it, and then there is the renewables library, which is a library of regularly referred to energy and national policy to do with renewable energy developments. We also have sitting, which is used commonly by a lot of appellants in the normal appeal process, is our core library of development plans and other guidance documents. Again, they're all held in a library system that we control. So hyperlinks to those documents mean that we don't have to process the document again and make sure it's ready for inclusion on our website. So that's essentially what we're going to do. We're going to send out a list of everything we already hold and let the applicant and the parties look at those lists and decide which ones of those they're going to want to use and refer to in their evidence. What I did want to stress is that when you see this list, is that those are not the only documents. They are just the ones that we have, and they're not intended to be a limited or restricted set of evidence that you can refer to. They're just the ones we have, and that's how we take it forward. What will happen is that the note of the meeting that I'll produce will have with it a sort of first draft of guidance as to how we'd like you to work with these documents, and you'll see from that more information about the whole technology of it, the digital management system, the use of hyperlinks, indexing and such like. What I do want to confirm is that it would really be ideal if you contact the case officer or other case officers in DPA for advice about how to use that guidance. So it's not really my area of expertise. So if you see it and you're concerned about it, there's certainly going to be some case officers ready to try and work with you to see if we can make sure everybody understands what's required. And that's the very purpose of the guidance note, is actually just to try and see if it's working well. So hopefully with your cooperation, we can get the system to be up and running very quickly. What I also want to say at the moment, because I'm not sure, but it's another COVID related issue. Right now, if we were to have an inquiry, obviously the council's, not the council, the DPA file, the digital file, would become the resource file for the purposes of an inquiry, because they've been held virtually. Had an in-person inquiry, normally the council would be required to provide a paper copy of all the inquiry documents for visiting members of the public. That hasn't changed at the moment. DPA will still hold the main source documents, but it could change, like everything, it could change between now and when the actual inquiry is held. So we just need to keep an eye on that. It's just one of these things that's going to change as the COVID restrictions change. So I think we've been able to, what we've been able to agree there, if I'm correct, is that you're working on, the core document library is going to work with the applicant, and you're nearly there with the working list of conditions. And so it's with a fair wind, we should get the council's views on them and start that discussion, obviously out with any involvement of myself, so that we can meet whatever timescales we eventually put in the timetable. That looks all very achievable. And the last item on that list is whether or not we'll be able to achieve a statement of agreed matters. And that might be something else you're already looking at directly with the applicant. It's certainly my preference for that. For those watching who haven't been involved at all, I'm really asking, as far as possible, for the council and the applicant to find areas of common ground, so that when we get to inquiry or hearing, we're not debating things that everybody's actually already in agreement with, so that the discussions that take place, we can really look at the matters that where there's a difference of opinion. Where's the count? Oh, Mr. Kelly.
I listen to what you say, ma'am, but when it gets to the inquiry and the hearing sessions, it's important to bear in mind that the statement of agreed matters is normally only an agreement between the council and the applicant. It is not binding on any other party, nor does it imply that any other party agree with these agreed matters. So I have no objection to it. I think it's a helpful process, but just to bear in mind that it's only an agreement between two of the parties. Thank you.
There's nothing to stop you once you've seen that agreed matters in making any further observations if you feel that you can align with any of the statements made. In fact, I'd be very welcome if any of the parties, once they've seen a statement of agreed matters for this case, if they saw that there was commonality with their own argument, then happy to accept any confirmation to that effect. I was just going to ask, the council, are you already working on statement of agreed matters here, or is that still something that's to start?
Thank you, ma'am. I think in general terms, what we would be looking to do is potentially have some additional time allocated in order for us to get to a position where we can provide a statement of agreed matters. effectively just to allow ourselves and the applicant to be able to narrow down some of the issues requiring further evidence and discussion. In that regard, one thing that I was hoping to suggest, because it's something that we did for another PLI for Fetteresso, which is running concurrently with this one, is we could suggest splitting the provision of information within the statement of agreed matters into two. And that would allow us potentially to be able to present documentation with regards to some of the energy and planning policy matters sooner in the process, and then perhaps then come forward with some information with regards to landscape and visual matters further down the line. One particular issue from our perspective is that we still require to confirm the appointment of an external landscape architect for that purpose, and we'll also then have requirements for example, site visit to be undertaken with the council's landscape architect once appointed, and with other external advisors as necessary. So in general, I would probably be saying if we could potentially have a date set closer to the time of the inquiry statement, but again with that offer of potentially maybe being able to bring what information we can in terms of energy and planning policy matters earlier in that process, but with additional time to be able to deal with the landscape and visual matters. Thank you.
Mr. Trick?
If it helps, we are preparing a statement of agreed matters which does cover all topics, and I can't promise a date for release for that because it involves our landscape and visual witness who's prioritising the AI at the moment. But once that is done, we could be looking at 4 or 5 weeks away, and we'll be able to send you a draft.
That's fine. That's looking quite positive. I think there's no reason. We're looking at the core document list, the conditions, perhaps working on a first draft and a second draft. So I don't see any reason in working with that or splitting between the more straightforward elements of agreement and then the later ones that need expert input, as you say, from people that perhaps haven't been appointed to act for you yet. I think that seems reasonable, and I'll look to see if we can work that into the timetable as far as possible, as long as it's coming in plenty of time to help prepare inquiry statements, really, because it can really assist in your own work when you're concluding your inquiry statement and recognition. I think that's everything on that item, and that takes us probably on to the next item, which is about the annexes, which are about the separate procedure. Item 6 on the agenda is looking at Annex E, which is first of all the relevant topics for the inquiry, and secondly the ones that are marked for no further procedure. Just to clarify, no further procedure just means we're not seeking any more information because we think we have enough. It isn't that we're not going to consider these matters fully in the report. My first question, before I take your question, Mr. Kelly, just for a second, is really is to just get some thumbs up that I've covered all the right topics for this particular case, and that the topics represent the matters that I should be considering. Nobody's saying contrary, so that's fine. I've got obviously Ms. Shaw's representation about ecology matters. We'll come to that shortly. Mr. Kelly, were you wanting to raise something now on the matter of the topics and the procedure?
Yes, ma'am, I do. I have pre-alerted Mr. Trinick to this. There is a very significant regeneration programme underway, multifaceted regeneration programme underway in the Cabrach, which is now looking to link in with the Just Transition programme for Moray and the North East. My clients have a concern that the proliferation of wind farms, of which Clashindarroch 2 is one, may have adverse effects on this regeneration programme and Just Transition. They are therefore asking for an additional hearing session. I have estimated no more than 3 hours, at which their concerns could be discussed alongside the responses of the applicants. And of course, we would comply with all of the normal prior disclosure requirements for the case. The discussion for that hearing session would be led by Mr. Jonathan Christie, who is the Chief Executive of the Cabrach Trust. there would be no attempt to broaden it into a wide-ranging socio-economic discussion, which you've said you don't need any further information on. It would be very specifically directed at the regeneration activities in the Cabrach and the potential effects. So we are requesting a short additional hearing session.
Would it generally be something that would sit underneath the socio-economics and tourism umbrella in terms of topic?
I would say not, because there's a very strong community and community involvement element into it. It is very specifically dealing with the concerns, are very specifically dealing with the regeneration activities and the just transition arrangements. It's not a general socio-economic and tourism issue.
I appreciate it's not. I appreciate it's not a general one. It says in terms of the topics. It's whether it would be a part of these broader concerns, but very specific to this Cabrach project. Probably before I say anything else, Mr. Trinick or Mr. Ingram, do you have a view on that?
Yes, thank you, ma'am. We've already indicated to Mr. Kelly that, of course, he must bring what evidence he wants before you, subject to your decision. I think if there's going to be an oral session on this, and we're perfectly happy with that, then we would want a statement at the earliest possible date from Mr. Kelly, which crystallises exactly what the case is founded on, what the topics are to be covered. Not just so that we get an indication of the case we have to answer to him for you, but also so that we know if we have to go and get another witness we hadn't anticipated. So I think it'd be very helpful if Mr. Kelly wants to bring this to an oral session, and it's your decision. Very helpful if he would outline within whatever timescale you see fit, maybe a few weeks, the structure of his case along the lines of an inquiry statement.
Yeah, I can see the difficulty with that. Obviously, we're reliant on the earlier representations from the two Cabrach. Presumably, it's a combination of the two Cabrach representations that you provided for us, Mr. Kelly. Is it coming from their original objections?
No, it's coming from their original objections and the ongoing work being coordinated by the Trust. I understand the point that Mr. Trinick has made, and I would be perfectly happy to provide a short statement to your specification within the sort of time scale that everybody else seems to be talking about just now of 5 weeks after you issue the minute of the meeting. I'm happy to commit to providing that statement.
I'm a little bit concerned in the sense that I'm not quite sure, as Mr. Trinick's alluding to, exactly what we're discussing, and therefore setting time scales for it. Yeah, I think it might be something where we need to look at having the information, I think perhaps as soon as possible, really, so we can start informing the timetable, because I would rather know what it was we were going to be considering to work out whether or not there needs to be a hearing or a written submissions process, which could possibly be an alternative for you to put forward the current regeneration work and how that you perceive that is affected by the wind farm proposals, and that would allow the applicant to come back to it in a normal written submissions exchange. I'm not inclined at the moment to go down the hearing route when there's such a level of uncertainty as to what we're actually going to be discussing. What would you consider to a written submissions approach to it?
I'm not quite sure what to hear. There is already ministerial involvement in this matter through the Just Transition Programme and with the local MSP being the Minister for Just Transition. He has visited the Cabrach Trust and discussed in general terms their concerns about the potential for the wind farms, and it's a series of wind farms, not just Clashindarroch 2, to impact on the aspirations for the regeneration of the Cabrach. It was following that discussion that I had a discussion with my clients, and I have been asked to seek a hearing session. I specifically, in anticipation of some of the concerns you've expressed, ma'am, I specifically put to them, did they want, following their discussion with the Minister, to have a written submission or a hearing session? And my instructions were to seek a hearing session on this matter. I've given very careful consideration to what is likely to be covered. I'm happy to provide that statement. I'm also very confident a period of 2 or 3 hours would cover all of the issues perfectly adequate in a hearing.
Okay, does the council have a view on this process?
Ma'am, we would be happy to go along with the suggestion that you made, that if perhaps Mr. Kelly could initially arrange for a written statement to be provided or some form of written submission in that regard, and that would at least then provide us time to give consideration to that and whether it required any further input from ourselves. Thank you.
Mr. Trinick?
Just slightly concerned about one or two of the things Mr. Kelly said. The purpose of this inquiry is to provide you with the additional information you need in order to report to the ministers who are outside the loop at this stage. This is a process independent of any ministers. It's not a political process. And secondly, Mr. Kelly's mentioned other wind farms as well. Let's get it clear. This is only about Clashindarroch 2, not what might come afterwards as well. So we've got to be a bit careful about the parameters put around this particular topic. Subject to that, I'm ambivalent whether we have a written representations process or a statement by Mr. Kelly, which enables you, following taking views of others, to determine procedure, whichever is the most efficient.
Right, I think in terms of this one, I would be inclined to really go with Mr. Kelly's suggestion or willingness to provide a sort of summary and more focused statement of what we're considering, and have only a provisional slot for a hearing at this time until we've seen that. At that point, I think I would need to then decide on whether a hearing or written submissions would be appropriate. But I'm because it's quite a new issue and it's not really fully documented in the representations to date. It's alluded to in the Clashindarroch ones, but it's not documented. I'm reluctant to agree to a hearing right at this moment in time, but I'm willing to keep my options open for that. Would the parties be content that I was able to do that, bearing in mind that I don't really have the full nature of the Clashindarroch issue in front of me? So you agree that I wouldn't normally do that, but I'm really not sure what it is I'm going to be hearing about, and therefore what the benefits are of the oral procedure at the moment. So that's how I would take that one forward. And that takes me to actually, sorry, Ms. Shaw, we can overlook you, and we were about to kind of go down the route, because obviously you were good enough to tell us yesterday your concerns on the ecology topic. Perhaps you could explain what it is you were looking to achieve there.
Thank you very much, Mark. My client, of course, appreciates the preliminary assessment that no further procedure is needed on a given topic doesn't correlate with the perceived importance. But notwithstanding, their position is that ecology remains a critical issue to the determination, and their objection, particularly in connection with the presence of the Scottish wildcat at this site. We understand that there are currently broad differences between professional witnesses, as well as questions as to the basis on which the statutory consultees have arrived at their conclusion, and it's our position that these would require to be considered, evaluated, and the context to be properly tested. And we submit to you that these issues would require to be aired if ministers are to have a complete information to support them in reaching their determination. Our position presently, bearing in mind what I'd said earlier about outstanding information, is that it would be proper for this to be canvassed as part of an inquiry session. In the normal manner, we would obviously look to focus the elements and to, work on the nuances, and it might thus be quite a shorter session in the order of half a day to a day that we're envisaging. But my client's position is fundamentally that the nature of those differences is detailed and technical, and such as to require cross-examination. They're not interpretive matters. I think basically there is a secondary issue in relation to fairness, bearing in mind the delay in SNH's lodging of its original objection. Obviously, my clients did not have the benefit of sight of that position at the time of lodging their original objection. And I think I'm wondering whether one way to deal with this might be for us to put forward also a written further submission with a provisional note seeking an inquiry session in relation to ecology matters. It's a dynamic element and we're guided by you, but our position is ultimately that this is based on fairness.
Mr. Trinick.
Well, Susan Shaw ended up with a suggestion I was going to make, so I agree with it. That I think if Wildcat Haven do want an inquiry session, we're perfectly happy with it. If it helps to inform you as you need to be informed, it's your decision. We'll go along with whatever, provided we know what witnesses we've got to provide. And we won't know that until we get the inquiry statement. Also note that in earlier correspondence, there were some hefty legal submissions made in relation to this particular topic. And I think for your purposes and to help us, it would be useful to see the content of the legal submissions at an early date with all cases to which reference is going to be made, to give us a chance to prepare a response in readiness for the inquiry. The last thing you want at inquiry is an exchange of legal submissions, which takes up a huge amount of time.
Yeah, I'd appreciate it. There is 2 or 3 themes through Ms. Shaw's original objection, and they cover the legal process, environmental impact assessment, and the competency of the overall process as submitted by the applicant. There's also the regulatory arrangements to do with the protected species and the framework that guides that. And then there is this question, technical issue about whether or not the methodology of ecological surveys on wildcats and the risk that's been attributed whether or not that has been done correctly or not. I'm wondering if I appreciate that the technical issue around attributing risk to the species and making judgments about that species is a technical matter. I could understand that there being merit in an inquiry session around that. I'm wondering whether or not the other matters, the legal issues and the regulatory framework, whether or not that would sit better as written submissions, and that we exchange written submissions between the applicant and presumably Ms. Shaw on behalf of Wildcat Haven around these legal processes and the EIA, with a view to then really doing a very focused inquiry session on any differences regarding the risk to the wildcat and how that risk has been assessed. I'm simplifying that. I know that's maybe not the full issue, but if I see it as I simplify it in those terms. Mr. Trinick, would you feel that would be helpful to split it that way so that the inquiry was on ecological technical matters?
Yes, I would. I don't think we need to take inquiry with legal submissions or at all, or points about EIA or nature conservation law or whatever it is. Those can be dealt with in writing perfectly satisfactorily. Technical issues, yes, if they need to come to inquiry, you feel they need to be informed on the topic, then that's fine.
Ms. Shaw, how does that figure in your expectations there?
I think we're very happy with that suggestion and proposal. Just one point of clarification. That our any further written submission would not be restricted only to wildcat issues. It will be the full spectrum of our original objection, bearing in mind what I'd said about not having access to some of the information, etc. earlier, and the reservation that we sought to include in our letter of objection accordingly. So it wouldn't be new matters, it's envisaged matters, but it wouldn't be restricted only to matters relating to wildcat.
wouldn't, right, okay. I wouldn't really want, I know your letter makes reference to, for example, to landscape and visual matters. I really don't want there to be any engagement on that. I have some reservations regarding the position you take regarding the relationship between the applicant and forestry, the owner of the forestry land, which is Forestry Land Scotland. Is that correct? Have I got the right title? I'm less inclined for that to be a matter for the inquiry. I think that might go beyond anything that I am required to consider, but that would be my only concern about broadening it to everything in your letter.
Sorry, no, for clarification, I'm referring here to the matters within the scope of the environmental impact assessment.
Would you need access to the confidential information at some point in time to be able to do the written submissions, or would the confidential information be something that would be more appropriate as you prepare for inquiry, assuming the confidential information is about the survey work and the underlying sensitivity of that species? I'm thinking in terms of timing. I'm not thinking about excluding information from you at all, but it's more like whether or not you need to wait on the confidential information before you could do the written submissions.
I mean, I think ultimately our position is that we've been trying to gain access to that information for quite a substantial amount of time now. But I think ultimately the sooner we can clarify that, the better, and the sooner that we can clarify our full position in the applicant's hands here, but that would certainly be my position.
Mr. Trinick, do you have any view on this confidential information and how soon we could get it?
Yeah, I think it's a preliminary issue, I think, that comes before everything else, because if for whatever reason the information isn't going to be released, then that will affect the technical evidence which is brought to the inquiry. So can I suggest that as a preliminary issue, which is dealt with very quickly, we hear from Susan Shaw on the confidential information. We can get that out of the way and then move on to legal submissions as one strand and onto the technical evidence as the second strand.
Right, I think I've got that. So the plan would be to look at sharing confidential information in a condition that everybody would be happy with, that Wildcat Haven then are able to refine their position in light of that. We then take forward any legal procedural matters, regulatory framework for protected species. We take that forward into written submissions, and following that, we then have a focused inquiry session on any remaining concerns regarding the technical matters of assessing the risk to the species and how that's been interpreted through the EIA. Is that the correct understanding of where we're taking that then?
It is for me, ma'am. Just subject
I think that's sensible.
Sorry.
Yeah.
Yeah.
Apologies, Mr. Shaw. Just one point I had, that I may be misheard something you said, ma'am, but when it comes to the way in which we hear evidence, we can part perhaps with confidential information on terms which acknowledge legal restraints. But any evidence given in the inquiry will obviously be given in public. There's no provision for in-camera evidence for this sort of topic. Okay. So we have to bear that in mind.
Obviously, we've come across this before with protected species, and I don't know quite which, because I don't know what elements are confidential at the moment. Excuse me, I don't know what the sensitivities are here. Certainly, if I use something that's perhaps not about wildcat, if we talk about badgers, for example, and I know that we would never publicly share the location of a badger set, but the specialist people involved are able to see the locations of the badger set. It's just not in the version that the public are able to view, and things are redacted, they're blanked out with that. Is that the type of way we could go forward, where the people giving evidence have access to the sensitive element, and what we publish online is redacted. Is that going to be acceptable?
From my perspective, yes.
Yeah.
That works.
Yeah, I think that's normally how we'd approach it on something that's a more commonplace problem, which is the badger set one, where we've most planning authorities and the DPA have had to work around a means of explaining the risk to badgers, but without showing the badger set. So if we approach it in that manner, hopefully we can get enough information to the ecology witnesses within Wildcat Haven's team that allow us to conclude on this. Right, I think I'm quite happy with that. Actually, I accept your issues of the technical thing. I was reluctant to have the whole discussion about the legal matters inquiry. So I think that's going to be a suitable compromise. We'll try as best I can to document all that in the note of the meeting. If for any reason I don't get it quite right, I will accept. I'll give a period for comments on the note of the meeting, just in case any of this is not 100% what you thought we were agreeing to just now, because it's quite complicated, but I think I've got it. That takes us on to the further written submissions, which are the ones that I've identified myself, which is item 7 on the agenda. And really that's about noise. That would be something I think only the council has a direct interest in. The council indicated written submissions, Mr. Trinick?
Yeah, I think it goes a bit beyond that. I think we've got it pretty clear now, following recent exchanges with the council's environmental health officer, that that officer has indeed, as confirmed in her initial response to the application, no noise issues. This is not a technical issue. It appears to be a policy issue, which has driven the council to object on noise grounds. So we are left a bit confused. And I think we need some clarity here in the form of a statement from the council within a very short period, weeks or so, whatever it is, after this examination, PEM, telling us what exactly it is there is a problem about with noise, operational noise. Then I think you will be in a better position to determine what further process may be required, if any, to address the matter. It may be that it comes down to a debate at the policy session. I don't know yet. We need to know from the council.
Madam, can you hear me?
Yes, Mr. Newman, thank you.
Thank
Yeah.
you. May I just interject? I'm not clear on what basis it's said only the council has an interest in the noise issue. What does this mean?
Oh, sorry, that's my shorthand, in the sense that the council has made a formal objection on noise matters and is a participant to the inquiry on noise matters. Were you expecting to participate on the issue of noise?
I have some experience of the unreliability of the approach that in the past Vattenfall have taken over noise issues. And if it is considered germane, I would like to be able to provide a brief statement about this when it comes to the hearing.
The purpose at the moment is we're trying to focus on what the hearing would be about. So it wouldn't be about noise in the broadest sense. It was going to be about the noise where the council was uncomfortable about agreeing that there was no noise issue. And it seemed to be around the issue of cumulative noise in terms of the noise from the proposed wind farm and any existing wind farms that operate in the same environment. I would be happy if you wish to make written submissions into that process that clarified what your concerns were, along with the council's position, and that we then take both of those forward and make a decision as to whether a hearing is necessary.
Thank you. Thank you.
I think that would be quite helpful. And then I think, like a lot of what we're doing today, it seems to be that we just don't quite have enough clarity around the scope of the issue to be able to make a decision properly about the full process. So I think submissions around noise and concerns around noise, if we could have them in a short time period, and to ask for the council and Mr. Newman to do that first, and then Mr. Trinick and the applicant's team would be in a position to come back either in written comments on that, and we could make a decision at a separate pre-examination meeting as to whether or not it needed a hearing. It could well be that the hearing on conditions might actually be where the noise matter ends up, and we don't really know for certain yet until we see what the nature of the problem is.
That's my concern, having been here before with noise in particular. It can fall into three bins. One is policy, which is very easy to deal with. The second is conditions, and the third is a real technical issue about noise. And what we really don't want is to drift into a condition session and it only then becomes clear that what you really needed was a hearing session about those technical issues.
Yeah. Okay. Yeah.
Madam, should I submit something in writing to you, which it can be considered if it's germane at all, and if it is germane, under what heading you put it?
Yes, I think what I'm going to do, what the note of the meeting will do, will be to invite comments on particular items to do with noise. At the moment, I was looking at the cumulative noise issue because that's the area where the council was concerned. But I would take representation from you, a written submission as to what part of the noise issue you were concerned about. Obviously, I think you need to be very cautious if your concerns are about the way noise is managed in a separate wind farm proposal, which obviously I won't be considering, but I would be, because I'm looking at the cumulative impact, it could be that your concerns are about the cumulative effects of the existing situation and the wind farm, which means your concerns may fit into the original topic. Mr. Ingram, you were going to ask something there.
Thank you.
Thank you, ma'am. Not so much to ask something, but maybe just to give the council's current position with regards to where we are with the noise issue. First of all, just to confirm, the situation has been outlined to you by the applicant is essentially correct. That from the point of view of our environmental health service, they are in principle content that matters are capable of being resolved through conditioning with aspects such as the selection of an appropriate wind turbine model, design and mitigation scheme if necessary, etc. But in terms of the general principle, that's correct. The Environmental Health Service is of the view that this could be resolved. So going on from that, the issue really is with regards to some technical difficulty in reconciling this with our existing planning policy. However, I think it'd be fair to say that there's a will from our planning service to see if we can reconcile that with a view to getting matters resolved before the necessity of that having to be dealt with through the process of an actual hearing session on it. So I think our suggestion in the first instance would be to see whether we can agree some form of wording for a condition alongside the applicant so that we can then consider that condition wording or have that in front of you for your own consideration. Failing that, or indeed in alignment with that, depending on where we are with that, we would also be happy to potentially set out our reasons in relation to a written statement. But I think in general terms, our hope would be that in the first instance, we could deal with this matter by way of a worded condition that would meet the satisfaction of at least both the council and the applicant, and then could be put forward to yourself for consideration. And failing that, we can then provide some further reasons by way of written statement if that were required. But we would probably appreciate an opportunity to investigate whether that can be dealt with by way of condition in the first instance.
Mr. Trinick.
Yeah, I'm broadly happy with that. I'm always nervous on this topic of noise for reasons I've already indicated, and there's a further reason for nervousness, that if it turns out as a result of discussions which take place unnecessarily over a period of weeks, that there is an issue which does need to be tackled technically, that technical issue may or may not require the provision of more environmental information. And I don't want to be in that position too late in the day. So I revert to my original suggestion, which is that the council be asked to articulate very clearly what its problem is with noise within a short time after this meeting. Then we'll know what we have to do. And if we can clear the AI issue, that clears the timing issue. We can then move on to informing you in such a way that you can decide whether or not any further process is needed.
Yeah, I think I would. I think I'd be happy to, in a way, stick with the approach that it's a written submission, though. I think I would like the council to provide a written submission on the problem of noise, that with the as a precursor to deciding whether or not any further process is required, and that written submission would be something you would be able to respond to once it was received. I wouldn't ask for. I would stage the written submission so that the applicant was not expected to provide any information at the outset, but could respond in writing initially, and then gives us an option perhaps to pick up Mr. Newman's concerns, and also then at our second pre-examination meeting we can actually clear or not the issue of noise and work out how to go forward. If there is a technical issue, I'm hoping we'd be able to identify that as soon as the council's put forward its written submissions, and obviously the applicant can respond accordingly if they feel it's taking us into an area that requires additional information. So I think it'll be written submissions, but first from the council and from Mr. Newman, and then we can look at a response from you that is appropriate, and we then look at what that means to the inquiry. Because at the moment I don't really want to timetable a hearing or an inquiry session on noise if we don't need to. It seems as if the council's particular demeanour today is that they would rather find a solution, and I think that's where we need to go with that at this stage, and work with that first. We've got this option of the separate pre-examination meeting for us to pick up these things and finalise the process, rule things out, confirm things are not changing. So I think that's how we'll do it just now, and as far as possible I'll make rulings as we go along. If things are looking quite straightforward, I'll be able to share an opinion on these matters as soon as we've got a proper exchange. So I think I'll leave noise essentially as it is in terms of my timetable, but with the applicant being asked to respond to it rather than give initial thoughts. Does anybody have any other views on the issue of noise then? Is that a way forward? That's great. I'm realising we've gone way past the hour when I was going to stop, but we're right in the middle of the wildcat matters. I'm really about to start having a discussion on the landscape and visual inquiry session and then the overall timetable. Do parties want to keep cracking on and just get it done, or do you want to take a break? Just keep going? Yeah, we've come this far, right? Okay, here we go. So we are moving on to the inquiry session, which the applicant has asked for. I have to say I think it's appropriate. It's quite a technical matter. We're going to deal with it once we've had updated landscape and visual information, hopefully, from the applicant in terms of the timescales we set. My first question really on it is the scope of the overall session. I'm just conscious that we've got daytime effects, landscape and visual effects, and then there are nighttime effects to do with aviation lighting. And then there's this issue of the visual impact of the borrow pit work. And I'm wondering whether or not all of that is one big session, or whether or not the parties feel it falls into separate groups, or whether the borrow pit itself can fall out of the inquiry session and be dealt with by written submissions. So I was really looking at how we divide that up, if at all. If parties are happy that it's just one big session on all the landscape and visual matters, then that's fine. But I'm interested to see what your views are. So probably Mr. Trinick.
I'm happy that we want one big session to cover all these topics.
Yep, the council.
We would agree with that position, ma'am. Thank you.
And you're happy that Borrowpit stays in the mix as an inquiry matter? Yep.
Yeah, I believe we are happy with that being still in the mix for the time being. Thank you.
Now, just when we've got the other parties here, Mr. Kelly, I just wonder, are you intending to participate in the landscape and visual matters? Is that part of your remit from your clients?
At the moment, ma'am, yes, it is, but there's a couple of caveats there. We need to see the updated cumulative landscape and visual impact assessment. We also need to see Nature Scott's response to that. And we also need to see who it is that the council appoint as an external landscape consultant. Once I know that, if I assess that the probability is I would agree with 99% of what he or she would say, I would not intend to trouble you with duplication of evidence. I would withdraw from giving evidence at that point. So at the moment, it is intended to participate, but if the evidence is going to be covered by others, then we would withdraw from that session.
Thank you. Are the other parties interested in actually participating in the inquiry session on landscape? I'm thinking perhaps Mr. Mackenzie's evidence is of that nature, maybe some of Mr. Newman. Were you interested in actually taking part and giving evidence to the inquiry?
About landscape, are you asking?
Landscape or visual matters?
I don't think so.
Thank you. Mr. Mackenzie?
Thank you, ma'am. Yes, I think I would like to participate in that if I can expand on my submission.
Yeah, no, that's fine. Are you familiar with the process? Obviously, if you've seen the annex to the inquiry, the issue of providing a statement and the recognition, and that would give you a seat at the table, as they say, if you were providing evidence of that nature.
Okay.
It would be possible to fully rely on your original objection.
Yes, thank you. No, I think in that case, my original objection stands and I won't need to participate.
Obviously, it doesn't preclude you from following the event and potentially attending, depending on the venue, and by being an opt-in party, you will be advised and involved in any exchange of information as part of that. But thank you for that. So the next question on the landscape is really just how long do you think the inquiry session needs in terms of a diary? Is it a day per applicant, a day per council? What's the party's views?
I would allow 2 days for that session. I think the vast majority of it will be taken up by daytime landscape and visual effects. I don't think Borrowpits will take that long. And I believe that lighting won't necessarily take that long either. So I would anticipate certainly leading my witness in 40 minutes or so and cross-examining. This is on the basis of past experience only, the Aberdeenshire Council witness for no more than 2.5 hours, 3 hours. So it looks like 2 days maximum, I would have said.
Does the council have a view on that?
Thank you, ma'am. Yeah, I think in general terms we would agreeable with a period of around 2 days for the entirety of the landscapes and visual assessment aspects. Obviously, there's a certain aspect of guesstimate in our behalf, and that we haven't quite got as far as having an external landscape and visual experts to consult with in that regard. But what the applicants put forward sounds reasonable to us. Okay,
that's fine. So we can look at a timetable that allows for 2 days for the inquiry session. You'll see, obviously, Mr. Kelly's point was raised there about Nature Scott being advised of the updated information and the importance of being able to see that. I think with the timescales that we're now working to, I think there will be plenty of time for us to get an updated position from Nature Scott on the landscape and visual matters, and for that to be with you in plenty of time to inform your case. Mr. Newman, did you want to do something?
It just occurred to me that Mr. Hammack hasn't been able to join, has he?
No.
No, and I think it's quite likely that he would have some contribution to make on landscape and visual issues. So I think maybe that should be should be taken into account when estimating. But you're going to be in contact with him, aren't you?
Yes. I think I think he's on holiday, which is why we haven't had a reply
Yes.
to
Yes.
get him to kind of give a bit more clarity on what he was involved in. I think one of the purposes of the note of the meeting will be to actually get in writing from everybody which sessions they want to be involved in. I'm merely canvassing in the course of the meeting because it's helpful to know as we're discussing who's actually looking at participating. If Mr. Hammack wants to be involved, we need to have a look at the time it might take to hear his evidence and any questioning that might take place. It could be that we allow a runover period, so we've got 2 days and a runover time that gives us a little bit more space should that be necessary. But if we can deal with it in the 2 days, then that's fine. I think that's quite common that I've seen in timetables before that we leave a little bit of wriggle room in case the landscape and visual information takes longer than we envisaged, rather than having to reconvene at a later date and the difficulties of rescheduling expert witnesses and such like. So I think perhaps that might be the solution, is that we have some runover time. We can look at what Mr. Hammack might be wanting to add to the inquiry process. It could be once he sees what's involved, like Mr. Kelly, once he sees what's involved, perhaps he may not need to, he may feel that the council is going to properly represent his position. But we don't know that, so we'll need to allow for that. And that would obviously pick up, that wriggle room obviously then picks up whether Mr. Kelly presents evidence and a witness in his own right at some point too. And we've obviously covered in my agenda here, obviously, was the issue of summary of cases, but we've obviously covered that already. So the importance that we get through that inquiry evidence something that will work as a good summary of the applicant's position or the council's position or any of the third parties that are participating, so that I can properly do them justice in the summary in my report. And that leads us on to the hearing procedures. We've obviously discussed it already. I saw that the council and the applicant were keen to have a hearing on policy matters, so I've just incorporated that into my timetable, and I saw that Ms. Shaw wanted to have a chance to participate in that as well. I'm assuming, Mr. Kelly, were you interested in the policy hearing too? No, it's really just a case of giving a best estimate as to how long the policy hearing might need. Is it a half day or a whole day to get through the evidence? I haven't really got a feel for it yet at the moment, I'm afraid.
Well,
Mr. Trinick,
depends on your agenda, ma'am. If you set
yes.
some difficult exam questions, will take longer. I would say half a day is the maximum.
Yeah, that's fine. Would the council, Mr. Kelly and Ms. Shaw, do you feel a half day to work through the areas of policy that are of concern, remembering that we will be focusing on the parts that are of most importance rather than looking at the entire policy framework for assessing the proposals?
Yeah, that's agreeable with us, ma'am. Thank you.
Yeah. And the other session, again, it's an undefined time period at the moment, and that's on conditions, because we don't know what level of difficulty there might be between the council and the applicant over the proposed conditions. I could allow a day, I could allow a half day. I think we might know better at the second pre-examination meeting, so I think we just allow a slot for a hearing. But the main thing, our party's happy that we keep a slot and that hearing is the best way to thrash out any concerns over the wording of conditions.
Yes.
It may be that I've got my own questions as well, which I won't know until I've seen your draft proposals. So we'll allow half a day at least just now, and we can review that at the second pre-examination meeting. I saw, Ms. Shaw, that you were interested in participating in the conditions hearing as well. Is that Is that correct? So you would wish to be?
It's certainly correct. Obviously,
Yeah.
we would keep that under review, and I think that we would obviously look to make our involvement in that as restricted as is possible, and it will be around ecology issues. Thank you.
Thank you. Mr. Kelly, you wanting to come in there?
Yeah, yes, ma'am. We would want to be involved in the consideration of conditions too, but I would hope that as many as possible of our concerns could be addressed by commenting on the draft, circulated draft conditions. So we'd like to see the draft conditions at each stage. Thank you.
Yeah, I think I can accommodate that. It's not a problem. And we can pick up where we are at the second pre-examination meeting. That takes us to the overall timetable. Obviously, we've now agreed to move everything forward to the week beginning the 28th of February. I'm looking at the timings we've talked about just now, allowing, say, half a day for an inquiry session on wildcat matters. It seems to me that we could accommodate hearing and inquiry sessions in a working week between the Monday and the Friday. Would that be the preference, to try and fit everything into 1 week as far as possible?
Yes.
Yeah, that's fine. So what we'll try and do is I'll try and work on a timetable based on starting probably on a Monday, I think, just to give us that bit of space in case the landscape and visual information takes longer. I know that's not so good for travelling time, especially if we are an in-person inquiry up in Aberdeenshire. We'd always be travelling over the weekends and things, but I think that is preferable than having not enough room and having to reschedule after in a separate date. I'd like to keep the timings that I have in terms of the run-in to the inquiry date. So I would like to look at a minimum of 6 weeks lead-in time for inquiry statements, the 2 weeks for recognitions. I want to push the final version of the conditions back into 2021 in advance of any pre-examination meeting. But I take on board, obviously, Mr. Trinick's suggestion that everything could really be secured before the end of December, and then have a clear run into the new year without it getting in the way. I'm happy to put that in because obviously my desire is to have at least 6 weeks lead-in time. If we went for 8 weeks, for example, and we hit Christmas, then the obvious thing is to move it into the end of the working period before the festive holidays. But I'm conscious that obviously has its own pressures on staff, and I just want to make sure everybody is happy if we go for a December submission date, that everybody will be content with that. Does anybody have a contrary view? No, that's fine. So we'll look at a December date for the submission of information certainly for the inquiry statements, so that everything's settled. Now that means at some time, maybe at the beginning of December, we look at a second pre-examination meeting. And I can really, maybe in my note of the meeting, I'll just pick a preferred week, and then we can start looking at everybody's availability in that week for a slot for another hour or so to discuss this. Then in terms of the start at the beginning of the process, again, I've hoped to have the note of the meeting out next week. It acts as a procedure notice of sorts. It's going to set the requirements on you. We'll be looking at 2 or 3 things coming in on the 3 weeks timescale, some other things coming in at 5 to 6. And I think that's giving us plenty of time for written submissions. And I'll try and jig the timetable so everybody's responses to anything that we have coming in the first part of this timetable can be done before the next pre-examination meeting, and that we use that as a catch-up, and we look at where we are and whether or not it's having an effect on the process. Obviously, there'll be other things that we can decide at the time, such as some of the issues around the wildcat hearing session and the matter of the Clashindarroch regeneration project. And we might be making early decisions on those about how that affects our timetable. Does that seem about right for everybody? There's nothing there giving anybody any serious problems. And and unfortunately, it's just a matter for the councillors to work out whether or not they're able to keep with their original legal counsel for the inquiry. And then that takes me to last item, was just closing submissions, just to say we would probably finalise those at the hearing and the inquiry, but I would expect them to be in the sequence of all parties other than the applicant submitting within around a fortnight's period, and then the applicant having additional time after. That's a standard convention for closing submissions. I don't think anybody's going to have a problem with that. Is there any other business that I haven't covered that you want to ask me just now? Everybody happy with we've caught everything? Right, thank you very much. Well, thank you for your indulgence. This has been longer than I expected, but we had slightly more technical things to deal with around these more unusual issues that we have in this case. As I say, the note of the meeting that I'll issue next week will look at the process, the requirements for additional supplementary information, give you advice on the core documents, look at the issue of the inquiry date and set out reasons why we've moved it from the 30-week slot, confirm up the timetable, confirm some details for contact details for parties. I think we've more or less got all those agreed, but just make sure they're all in place. I'll set a date for, or a preferred date for the 2nd PM, and I'll look for some more confirmation from parties about involvement, size of the teams, and that sort of thing. So those are the information. So there'll be a wee bit of work to do immediately just to respond to that note of meeting. And I will give you an opportunity to comment on it before I finalise it, just in case I've not represented something quite right, because it is quite complicated, some of the processes that we're trying to put in place. So thank you very much, and I think I'll bring that to a close, and I'll say farewell till we see each other again, probably in December sometime.
Thank you,
okay. Thank you very much.
Thank you very much.